Yeah, good afternoon, and thank you for taking the time to join us today. I'm Dr. Stefanie Lemke, and together with my colleague, Dr. Cong-rui, we organize EnRoL, the Human Rights and Rule of Law Speaker Series. We give the floor to female role models, practitioners, and scholars who discuss with us latest developments in human rights and rule of law. Today, we want to dedicate this webinar to a very important topic, survivors of domestic violence. In particular, we want to look at the empowerment and how it is dealt with their cases before the European Court of Human Rights in Strasbourg. And we are very pleased to have two outstanding experts on these topics with us. Dr. Julieta Marotta. She's an assistant professor from the United Nations University and also from Maastricht University, and also Dr. Marotta Ronagh McQuigg. She's a reader from the Queen's University of Belfast. What we will do in the following is that we will first give a floor to our speakers. Then this will be followed by comments by my colleague Cong-rui, and then we will give the floor to you for your questions and comments. And please also feel free to type your questions and comments into the chat box. And then I will hand over to Julieta and her presentation with the title Legal Empowerment and Access to Justice, Insights from Victims of Domestic Violence and Adolescents in Care Homes. Julieta, the floor is yours.
Okay, good. So I was going through the thank you to everyone for being here and for the kind invitation. And I said that it was a pleasure to share the panel with Rona. So thank you very much. It's good to be here. The presentation of today is on legal empowerment and access to justice. And I will be working with two groups, victims of domestic violence and adolescents. And the main takeaway of this 15 minutes presentation is to show how the rules, the legal frameworks has been changing in order to address the access to justice of vulnerable groups or disadvantaged groups. And then I will bring empirical evidence on how these changes were perceived by these groups based on empirical research that was done in the last years. So the legal empowerment approach comes after the extension of the narrow understanding of access to justice. If you recall, access to justice before it was assimilated to a fair trial. And then we see that access to justice became a comprehensive concept. And then we understood access to justice as the vehicle where other rights are conveyed. And the legal empowerment came as an approach to understanding access to justice. And this approach focuses on the particularities of individuals to increase capacities to resolve conflicts and gain control over problems. So it takes the law as a tool for empowerment and understands that once people have access to the laws, they can better start solving their problems. So the law becomes, again, a source of empowerment. I have been building on a theoretical framework proposed by USAID, in where they describe the access to justice in a cyclical way and explain that in order to gain legal empowerment, there has to be a number of elements. One is that the law needs to be developed in a way that's a rights enhancement, in where people can actually have legal tools in order to attain access to justice. It incorporates the rights awareness as a fundamental element where people need to be able to understand their rights in order to be able to exercise them, this rights enablement, and through different organizations that are capable of actually allowing them to exercise their rights, and that there has to be the possibility of people to enforce those rights and to participate in the decision-making of amendments to rights. And that there is where the cycle starts to roll. So with this idea framework in mind, I have been working with two populations. One is with victims of domestic violence who obtain access to justice, and I've done empirical work with through interviews to understand their perception of justice and how this empowerment, legal empowerment, went about, and also with adolescents in care homes that were displaced from their families due to cases of abuse and or neglect. These two case studies took place in Buenos Aires, Argentina. So Here I will bring you the first part of the rights enhancement. So how the law have developed for these two populations in order to secure their right to access to justice. What we observe is that the law has done an effort in order to make it tailored to the specific barriers to access to justice that historically these populations have been encountering. We see this with the Convention on the Elimination of All Forms of Discrimination Against Women, the famous CEDAW Convention, that strengthened the importance of access to justice to eliminate gender violence and violence against women, and puts the duty of the state to provide accurate channels for victims to be able to access to justice. Also, it strengthened the need for an expedite and simple system that can allow immediate protection to victims. So again, going into looking into what is that this population needs in order to obtain access to justice. Similar with children and adolescents, in where the Convention on the Rights of the Child tailor the access to justice to specific barriers of children. And here they go into the right to be heard and participate in the legal process, remembering that before the child was not able to participate by themselves, but they needed to have the voice of the adult representing them in view of their best interest and their evolving capacity, and the right to have legal representation. Then what we observe is that a number of countries, they introduce these standards into domestic laws. And in the case of Argentina, they have been enacting what we call comprehensive laws for domestic violence and for children and adolescents, where they take the subject as a whole and they address the different angles of recovering from the violation of rights that they experienced. In case of domestic violence, they readdress the right to submit claims or complaints in any court, even when that court does not have jurisdiction or competency over domestic violence cases. This is because it is known that for victims of domestic violence, it is a very big step to submit a complaint, and that the risk is very high when they do so. So the law understood that no matter where they go, the court needs to take the complaint and act upon it. Also, they give the right to legal representation, and there are a number of legal aid offices open to provide free legal representation to victims of violence, and the right to a holistic remedy, considering that given the complexity of the conflict, the law alone cannot solve it. So then they incorporate the idea of having a psychologist, a social worker, and a lawyer together working on the conflict of the victim of domestic violence. Similar happens with children and adolescents, where the domestic laws also incorporates and recognize them as subjects of rights. And they say that they have the right to be heard on the issues that attain their lives, and that the public and private actors they need to work together to guarantee their rights, and they also have a right to legal representation. The Civil and Commercial Code that was amended later incorporates a very interesting section in where addresses specifically the need to facilitate access to justice, especially for vulnerable people. And here the law is specifically having in mind victims of violence and children, and to achieve peaceful resolution of conflicts. With the peaceful resolution of conflicts, they are also hinting into not only alternative dispute resolutions, but the idea of having a holistic remedy to actually overcome the conflict. And a very important angle that it's also coming from the international law is that the judges needs to be specialized, and that people need to obtain multidisciplinary support. Again, with the idea that the law alone cannot make it in this type of complex conflicts. Now, when it comes to rights awareness, and here is where the empirical work comes into play, after data collected through interviews and through participatory methods with adolescents and interviews with victims of domestic violence, what it's observed is that most victims from the sample who obtained, or almost all of them who obtain access to justice, have secondary education. So there is a correlation there between education and actually approaching the legal system. Most victims ignore the legal provisions that protected them. So there is a big gap in understanding of what are their rights, and they hardly ever reflect to those as rights. They ignore the implications of the complaint, so they submit a complaint without knowing what this will mean for them and what type of action they will have to take, nor participation in the legal process that they have to take, and that becomes a surprise for them. And they rarely participate in the process with informed decisions. Mostly what they do is they follow directions, and it's a matter of luck how this ends. So they follow the directions from the different justice providers that they tell them you have to do this or you have to do that. None of them hold the judiciary accountable. So sometimes there was expiration of information or on possibilities to complain, and they didn't know that. Only there was one person in the sample who actually made a request and hold the judiciary accountable for what they were meant to do. The same with when we go into participation, we see that victims only participated when they were asked to make simple decisions on a reduced number of options. And some victims that made decisions for themselves, and here is where the legal empowerment starts to actually make also a justification empirically, is that they became more aware of their own capacity. So this idea of starting to be thinking and reflecting about what is their position within a conflict and how they can actually overcome that conflict starts to become more tangible when they see themselves actually making those decisions in a judicial process. And this capacity to understand differs between victims. And this is a very interesting, I think, to me, it was a very revealing finding, because many times we apply one policy to all in terms of how to explain the law. And in the end, each person understands differently. So there needs to be a number of interventions to make sure that people actually understand their rights. Most of the populations valued a lot the interdisciplinary assistance, specifically that provided by psychologists. And all victims, and also became quite interesting to see that all victims shared with other victims their experience and recommended them to actually submit complaints, even when they couldn't understand exactly what this was for, but they recommended them to speak up. For adolescents, it's similar findings in terms of understanding of rights. There is a limited understanding of rights. They viewed themselves as passive holders of rights, so they didn't perceive themselves as being entitled of rights. The access to justice was perceived as the involvement of an authority figure doing something on their behalf, doing something for them. And the right to be heard was associated with having someone doing what they wanted them to do, receiving help, and trusting someone who listened empathetically. So this idea of actually having them as subjects of rights, we are not yet there. They still perceive themselves as needing someone to solve and to take ownership of their own problems. And the right to participate was linked to inclusion, sharing moments with peers, and expressions of opinions. The best interest of the child was not understood, was the least understood right for adolescents, though some adolescents also associated with being protected, cared for, and free from harm. Few adolescents recalled meeting with judges or lawyers, and those who did often couldn't remember why and what was it about. So it was anecdotal evidence. Yeah, I remember meeting them once, or I think that once, but they couldn't remember why they were there and what was their function within their own legal cases. They didn't understand that there was a legal case open on them. The adolescents struggled to understand the purpose of the justice system and their role. And most of them also, similar to victims of domestic violence, they shared their experience with someone else. And if another adolescent was experiencing similar problems, they will encourage them to speak up. And they will say, I encourage them to speak up and to tell absolutely everything, not like I've done. So they also saw themselves as not being able to actually express all the truth of their situation. So As closing remarks, what we observe is that the legal empowerment approach is helpful to understand the relation between people and access to justice. The legal frameworks, as we've seen, they are addressing the specific barriers for different populations on access to justice. And this gives a lot of tools to actually make a better system to allow different populations to be able to claim for their rights. And that rights awareness, it's still the main obstacle to ensure legal empowerment. And here are some recommendations that maybe we can think along afterwards. To have programs for rights awareness for different stakeholders that play a role, but also considering the specific, the different type of people that we have in society, so as to make sure that we can address all of us in these programs. And the importance of explaining for the providers, explaining the people who are obtaining access to justice, where they are, what will happen to them, what type of participation is requested from them. And here they need to include innovative techniques so as to be able to express this correctly in a way that it's understood by the person who is obtaining access. And the quality of the service providers that becomes essential in all this process needs to be enhanced in order to support the self-determination and autonomy of those who access to justice in view of having a sustainable conflict resolution. So the idea is that through access to justice, it's not that it's the end of the conflict, but once someone obtains access to justice, this legal empowerment starts and people start owning capacity and ownership on their own conflict, and later with time this conflict might end up being solved. Thank you very much.
Thank you so much, Julieta, for your amazing presentation. In particular, liked at the end your recommendations that were then also tailored to the specific needs of people then also involved with victims of domestic abuse and those living in care homes. Thanks so much. I have many questions, but I will leave those to our discussion part, and then I will give the floor to Rona and her presentation with the title The European Court of Human Rights and Conceptualizations of Domestic Abuse. Rona, the floor is yours.
Thank you very much indeed, Stephanie, and thank you for the very kind invitation to speak this afternoon. Many thanks also to Julieta for her presentation as well. So the European Court of Human Rights has now produced a considerable body of jurisprudence on domestic abuse. However, the ways in which such abuse has been conceptualised by the court have evolved during this time, as I will discuss in this paper. So, although it was not until the case of Cong-rui and Slovakia in 2007 that domestic abuse was considered substantively by the European Court of Human Rights through the application of the concept of positive obligations, it has now been established that such abuse can constitute a breach of the right to life under Article 2, the right to be free from torture or inhuman or degrading treatment under Article 3, the right to respect for private and family life under Article 8, and the prohibition of discrimination found in Article 14. However, questions have arisen in relation to how domestic abuse is conceptualised by the European Court of Human Rights. In the court's early jurisprudence on this issue, its approach to the use of Article 3 and Article 8 was somewhat incoherent in terms of on which provision the court based its findings of a violation. So in certain cases, such as Opus in Turkey and ES in Slovakia, the court found breaches of Article 3. However, equally, there were other cases, such as Slovakia and S in Bulgaria, A in Croatia, and Kalypsa and Hungary, in which the court found violations of Article 8 only and refrained from examining the cases under Article 3 also. So essentially, the court seemed to take the view that if a violation was found, it did not matter to any great extent whether the abuse in question was deemed to be a breach of Article 3 or Article 8. Now, there were at least two possible reasons for the court's approach of finding violations of Article 8 and then omitting to consider Article 3 in certain cases involving domestic abuse. The first is that in the past, the court may not have fully appreciated the seriousness of domestic abuse and therefore may have been of the view that it was more appropriate to deal with such cases as involving breaches of the right to respect for private and family life, as opposed to the non-derogable right to be free from torture and inhuman or degrading treatment. However, it must be remembered that in certain relatively early cases, such as Opus in Turkey and ES and others in Slovakia, the court did find breaches of Article 3 in cases involving domestic abuse. So this explanation does not therefore appear to be sufficient. The second, more probable reason relates simply to the issue of practicality. It is a well-known fact that the court is burdened with an immense caseload. That being the situation, for reasons of expediency, the court often adopts the approach of finding a breach of one provision of the Convention and then omitting to consider the application of other provisions on which arguments have been made. The fact that in its early jurisprudence on domestic abuse, the court appeared to display a preference for the use of Article 8 over that of Article 3 may simply have been due to the fact that it can be somewhat easier to establish a violation of Article 8 than it is to establish a breach of Article 3. However, if the reason for the court's approach was purely that of expediency, the difficulty was that such an approach risked being interpreted as being based on principle, with that principle being that domestic abuse was only serious enough to fall within Article 8, but did not in the majority of cases meet the threshold of constituting a breach of Article 3. This was problematic, to say the least, as was ultimately shown in the 2013 case of Valulian and Lithuania. In this case, the applicant argued that the state had failed to protect her sufficiently from domestic abuse. The state, however, asserted that the treatment to which the applicant had been subjected had not attained the minimum level of severity to fall within the scope of Article 3. The state was of the view that as the applicant had sustained minor bodily harm that had not resulted in short or long-term health problems, and to quote from the state's submission, it could be said that the injuries sustained by the applicant had been of a merely trivial nature. The state did nevertheless present the court with a unilateral declaration acknowledging a breach of Article 8. Very interestingly, however, the court decided not to accept this declaration, found a breach of Article 3, and stated that it was not therefore necessary to examine the complaint separately under Article 8. The fact that the court in Valulian was not content simply to accept the unilateral declaration of the state that there had been a breach of Article 8, but no violation of Article 3, due to what the state termed the trivial nature of the applicant's injuries, is certainly praiseworthy. However, on the facts of Valulian, there seemed to be nothing to distinguish the abuse suffered by the applicant from that which had been experienced by applicants in other cases involving domestic abuse, in which arguments had been made in relation to Articles 3 and 8, and in which the court had based its findings on violations of Article 8 only. However, it is likely that the primary reason for the failure of the court to set out a principled rationale for its use of Articles 3 and 8 in domestic abuse cases was that it was actually impossible to rationalise the rather haphazard case law in a reasoned manner. It appears that the most likely explanation of the change in approach on the part of the court in Valulian lies with the actions of the state in submitting the unilateral declaration, accepting that there had been a violation of Article 8, but stating that there had been no violation of Article 3. If the court had simply accepted the state's unilateral declaration, it would at least implicitly be accepting that there had been no violation of Article 3. And it seems that that was not an outcome which was desired by the court. Indeed, not only did the court refuse to accept the state's unilateral declaration, but it also proceeded to make findings in its judgment that were, in a sense, the exact opposite of what the state had asserted in its unilateral declaration. Instead of agreeing that there had been a violation of Article 8, but not of Article 3, the court held that there had been a breach of Article 3 and that it was not therefore necessary to examine whether there had been a violation of Article 8 also. Since the decision of the court in that case, the court has certainly made considerably more use of Article 3 in cases involving domestic abuse. The judgment of the court in Volodina and Russia in 2019 again raised issues regarding the conceptualization of domestic abuse by the court. In its judgment in this case, the court commented that, and I quote, ill treatment must attain a minimum level of severity if it is to fall within the scope of Article 3. Even in the absence of actual bodily harm or intense physical or mental suffering, treatment which humiliates or debases an individual, showing a lack of respect for or diminishing his or her human dignity, or which arouses feelings of fear, anguish, or inferiority capable of breaking an individual's moral and physical resistance, may be characterized as degrading and also fall within this prohibition set forth in Article 3. The court was clearly of the view that the physical violence which the applicant, a victim of domestic abuse, had suffered reached the level of severity required to come within the ambit of Article 3. However, the court also emphasised the psychological aspects of the abuse which the applicant had endured, and commented that the feelings of fear, anxiety, and powerlessness that the applicant must have experienced in connection with the perpetrator's controlling and coercive behaviour were sufficiently serious as to amount to inhuman treatment within the meaning of Article 3 of the Convention. The court concluded that there had been a violation of Article 3 and also a breach of Article 14 taken in conjunction with Article 3. In Volodina, the court emphasised the important fact that domestic abuse is not only constituted by physical violence, but involves wider patterns of coercive control, and that forms of non-physical abuse can come within the scope of Article 3. The explicit recognition that psychological abuse is sufficient to meet the necessary threshold of severity to engage Article 3, even in the absence of physical injury, is meritorious and demonstrates the evolution which the court's jurisprudence on domestic abuse has undergone. Such statements on the part of the court are a long way from the understanding of the court's approach which was held by the state in Valulian. There is certainly no longer scope for a state to be of the view that a breach of Article 3 will not be found due to an applicant's physical injuries being insufficiently severe. However, in a separate opinion issued by Judge Pinto Dalbecke The judge expressed his opinion that although a breach of Article 3 was found in Volodina, it should have been held that the ill treatment suffered by the applicant went beyond inhuman and degrading treatment and reached the threshold for torture. In Ireland and the United Kingdom, the court had asserted that torture consists of deliberate inhuman treatment causing very serious and cruel suffering. And in the view of Judge Pinto d'Albuquerque, this threshold was met on the facts of Volodina. As the judge stated, the applicant in this case was subjected to multiple and persistent instances of extreme domestic violence. She was further psychologically taunted through the publication of private photographs, the finding of what was believed to be a GPS tracker inside her purse, threats to kill her, which the perpetrator attempted to substantiate by damaging her car, and abduction from her city of residence. As Judge Pinto d'Albuquerque asserted, when severe forms of pain and suffering are deliberately inflicted on a person, this must be identified as torture. The question of whether domestic abuse should be specifically conceptualized as torture arose again in the judgment of the court in Chunikova and others on Russia in December 2021. In this case, the applicants had suffered bodily injuries, including one case of severe mutilation, at the hands of their former husbands or partners, as well as receiving death threats from them. In holding that there had been a violation of Article 3, the court found that the state had failed to establish a legal framework to combat domestic abuse effectively, had not assessed the risks of recurrent violence, and had not carried out an effective investigation into the domestic abuse. The court also found that there had been a breach of Article 14 on the basis that women in the state were in a situation of de facto discrimination in relation to protection from the risk of domestic abuse. 3 of the 4 applicants asserted that they had been subjected to particularly extreme forms of domestic violence which caused them very serious and cruel suffering that amounted to torture as opposed to inhuman or degrading treatment. They argued that recognising severe instances of domestic abuse as torture would emphasise the gravity of the abuse in the eyes of the public, and the authorities tasked with monitoring and response empower victims and discourage or even deter perpetrators. In response, however, the court stated that the additional characterisation, although important for the applicants and capable of influencing the public perception of domestic violence, is not necessary in the circumstances of the present case, in which there is no doubt that the treatment inflicted on the applicants attain the necessary threshold of severity to fall within the scope of Article 3 of the Convention. So, by way of a few concluding remarks, the jurisprudence of the court on domestic abuse has certainly evolved considerably from an approach whereby such abuse was frequently conceptualised as a violation of Article 8 to a situation whereby use of Article 3 in such cases is commonplace. The court has clearly recognised that domestic abuse is not only constituted by physical violence, and that coercive control more broadly can come within the ambit of Article 3. Indeed, the question has now become whether domestic abuse should be expressly conceptualised by the court as torture. This would constitute a very meritorious development, as such a finding on the part of the court would strongly emphasise the seriousness of domestic abuse. As Jonathan Herring comments, there is a particularly strong stigma attached to torture, less than that found in references to inhuman or degrading treatment. Domestic abuse has been likened to torture, and in Volodina, the court referred to the need to adopt a gender-sensitive approach when applying the Convention to cases involving issues such as domestic abuse. It is certainly arguable that the adoption of such an approach would involve the recognition of the gravity and effect of persisting patterns of domestic abuse. As Judge Pinto Belberkirk remarked in Volodina, if the state faces condemnation for allowing its women to be subjected to torture, the positive obligation to protect is even more stringent. Finally, interestingly, in certain cases, such as Ireland and the United Kingdom, a state has attempted, albeit unsuccessfully, to admit to inhuman and degrading treatment in the hope that the court will not then consider whether the ill treatment in question actually reached the threshold of constituting torture. It is possible that a state could attempt to make such an argument in a case involving domestic abuse, thereby prompting the court to make a definitive ruling on this issue, much in the same way that the state's unilateral declaration in Valley resulted in a change in the court's approach in relation to its use of Articles 3 and 8 in domestic abuse cases. An express conceptualization of domestic abuse as torture may constitute the next development in the court's case law on this issue.
Thanks so much, Rona, for this fantastic presentation. I much look forward to our discussion. But first, I will hand over to my colleague Cong-rui for her comments on both presentations.
Thank you a lot, Stephanie. I really enjoyed both talks. I can see your talks actually present a multi-approach to understanding this very important and international phenomena. And I think the first question I'd like to pose is to Julieta. When you conclude that both groups that you interviewed seem to be kind of not really aware of legal protections applicable to them. And then I thought of a project that I conducted between 2014 and 2018. We look at how UN human rights treaties were taken seriously by the vulnerable groups in selected traditional societies, including China and Senegal. And when we interviewed women's groups or farmers groups, we realized UN treaties were not really taken seriously, not because of the groups were ignorant, simply because they didn't trust UN treaties or even their local courts would be meaningful in getting what they asked for. So I wonder, in your interview design, have you considered, when you mention access to justice, do you mainly look at access to formal justice, or you also consider the alternative forms of justice more familiar to the groups that you interviewed? When they neglect legal provisions, is that because of they lack the knowledge or simply they lack the trust? So that's my question to you. And for Ronagh, thank you very much for letting me know how the case law developed. When you mentioned this involving approach, I was thinking, apparently I didn't study this particular rights and the European Court of Human Rights, but I did study international criminal law. The crime of torture, you need to establish the intent to torture. So while listening to your presentation, which was very eye-opening, I was thinking, by having this involving approach, isn't that actually making the lives of victims harder? Now they have to present both the evidence of severe injuries on their bodies, and they have also to establish the evidence of the perpetrators, having this purpose to torture.
Thanks so much, Xiao. Julieta, would you like to start?
Yes, thanks. Thanks a lot for the remark, and I will be very interested in reading your work. So if you can send me in the chat, I will I will read it, because yes, the answer is no, but it's very context related. In Latin America, and this is different to Asia, the international treaties, and specifically those that are addressing vulnerable groups, they came with a lot of strength into the countries. And Argentina, for example, has been incorporating most of these international treaties in their domestic law very strongly. And they have been also used, if you see like decisions from the judges and petitions from lawyers, they have been using the international law as a way to give strength to their requests and also to their reasoning. And the population that I interviewed, that they were populations living in the city, so this might differ through population, and I think that that's a very interesting question or element to continue analyzing. They did not mention the idea of trust, and they did not mention using a different form of conflict resolution system. The most that I can assimilate to that is their talk among peers that makes them allow them to reflect, and that was most visible between victims of domestic violence, where adolescents they didn't speak among themselves about the conflict that they went into. And I assume that it's the age and also how painful this is in order of identities, and many of them they can still not realize what's the impact of this abuse in their lives. In the case of victims of domestic violence, it was very clear in all the interviews that they were mentioning how they spoke with other people about how to try to stop the violence. And they were saying, well, you have to do this, you have to do that. But they were always referring to accessing the formal system. It was only one case, and for victims that they refer to a religious entity that there is where the person receives support. But for the rest, they were all referring to the judicial system as a place where to go for help, or the police, but always referring to the state. But very, very interesting, and I will be, again, curious to read your work. Thanks.
That's super interesting to hear. Thank you a lot.
Yeah.
Indeed, very different. Like in China and Senegal, they usually referred to senior relatives in the community or the social helping groups. It's very different. Very nice comparative perspective. Thank you.
Yeah, thanks. Yeah, I think the China, it's all, yeah, Asia is fascinating to also understand the relation to conflict. It's very different how they approach conflict and how they approach these formal institutions. So indeed, yeah, well, maybe we can write something together to make the comparison.
Thanks so much, Julieta and Rona. The floor is yours.
Thank you very much, Stephanie, and thank you, Cong-rui, for your very, very good question as well. So in relation to sort of developing understandings of domestic abuse, yes, I think the fact that the court has now recognised that coercive control falls within the scope of Article 3 makes it easier for victims of domestic abuse to establish that the treatment that they have suffered falls within the scope of Article 3. And that's sort of reflective of, general understandings within states such as the UK of sort of the wider nature of domestic abuse, not just physical injuries, but also coercive controls. So I think that does make things easier for victims who may want to try and establish or to get it established by the court that the treatment they have suffered falls within the scope of torture. Yes, in relation to the intent point that you mentioned, which of course is very important in relation to establishing torture, there needs to be an intention on the part of the perpetrator for that to be established. Generally, I think in cases of involving domestic violence, I think the intent element will be present, because usually domestic abuse is intentional conduct. So I think that would probably be established in most cases of domestic abuse. But it's with the court then, whether the court will take the step of actually saying, well, yes, this is torture. I mean, the court has never actually stated that that particular conduct relating to domestic abuse does not fall within the torture limb, if you see what I mean. So the court doesn't necessarily say this is inhuman and degrading treatment, but not torture. The court just sort of says, well, it falls within the scope of Article 3, but doesn't expressly say that it is torture. So I think it would be meritorious on the part of the court moving forward if it were to actually expressly say that particular conduct falls specifically within the torture element, because it places more pressure on the state to respond more effectively to domestic abuse, if a state is in the position whereby the court is saying that certain of its citizens are suffering torture through domestic abuse.
Yeah, very helpful. Thank you for your clarification. I give the floor back to Stephanie. Thank you.
Okay. Did Rona answer your question, Chacha? Yeah. Okay, great. Then I have one question from Lucia for Julieta. Do you think that the case is decided by the Inter-American Court and the recommendations of Inter-American Commission reinforce the idea of empowerment of children and women? And she thinks about the convention of Belém do Pará from 1994 and the Brazilian law known as Maria da Penha from 2006.
Thanks. Indeed, yes. Belém do Pará, for example, has been very much used in the discourse and mostly in Latin America as a source of inspiration to domestic law. So yes, they are looked at and they are used again as a source because, for example, in the case of Belém do Pará, it gives a good understanding of the vulnerabilities of the group. And there it brings a lot of not only vocabulary, but also ways to frame the type of assistance that is needed. And there they come with strong vocabulary. When you read the parliamentary discussions to the enacted law in Argentina, it's one of the regulations that they refer to the most, Belém do Pará, and it's still very much referred in case law. Yeah. Thanks.
Lucia, does this answer your question?
Yes. I was thinking because, thank you, I'd for having considered my question. Thank you.
You're welcome. Are there any other questions or comments from the audience? Otherwise, Sefki, go ahead, please. Oh, I'm sorry, you are muted.
Can you hear me now?
Yes, perfectly.
Great.
Yes.
Thank you. I'm sorry. Okay, if you don't mind, I'd like to tell you a few things about my country, Turkey. May I? Okay, thank you. I'm afraid, as all you know, Turkey is not a participant of the Istanbul Convention anymore, and we feel its effects, unfortunately. I'm a lawyer, and I have been working around 35 years. And a recent study in Turkey, really similar to what Julieta explained and about the studies in China and Senegal. Many women still don't understand, don't know the legal aspects of domestic violence. They don't know the rights they have. And even if they try to get help, they don't feel a participant of the legal system. They feel like they are just an object on it. They are just a ball which the other parties play with. And that's sad. And there's an interesting point. I'm afraid I can't pronounce it well. She said that, for example, in some countries, elders are involved in cases of domestic violence. In Turkey, what we see is interesting. In small villages, As she said, domestic violence is mostly handled by elders. But in big cities where people do not know each other well, domestic violence is much worse, and people can't help from their elders because they don't have any in there. And the state, ever since Turkey withdrew from the Istanbul Convention, is very reluctant. The police is reluctant, and the judicial system is reluctant, and we lawyers try to do our best, but our best is not enough anymore. That said, and we are talking about a backlash, and in Turkey, I'm afraid we feel it very badly. But I don't know, we'll still keep on fighting. And I'm sorry, I just want to express myself. Thank you.
I may react. Thanks a lot for that comment, and I'm also will be very curious to see that study if you can send me the reference. It's very timely what you are saying, because what we see with CEDAW and with all these advancements in the regulation is that we thought as a society that we were better off, and that it was put out of the table that these legal documents were relevant and important to overcome violence against women. And the reaction to Turkey to the Istanbul Convention, the reaction of Argentina and the US to the latest UN Assembly resolution, also in relation to domestic violence, saying, well, these laws don't serve, they are based on feminists, how did they say it? Fanatic feminists discriminating the rest of the world. This is hinting that what you are saying, that the fight is not over, and we thought that some things were not coming back, and they are coming back. So I agree with you that we should be not very much having this type of conversations where we keep the topic alive and we keep telling to the society that there's still a lot to be done, and it needs to be stayed in the agenda. So the international agenda needs to keep this topic, and the national agenda needs to keep this topic as a priority.
Thanks so much, Julieta and Sefki, also for your comment. Are there any more questions or comments from the audience? Otherwise, I would have two small questions towards the end of this event. I was also wondering, Julieta, if you could provide a bit more information about the interviews you conducted. The number of interviews, who did you interview? I assume victims of domestic violence, also adolescents in care homes, but also, for instance, psychologists, justice professionals. So I would also be interested to learn a little bit more about the empirical part you carried out. And for Rona, I was also wondering if you also work together with stakeholders outside academia, and perhaps what's the take of NGOs on this latest developments at the European Court of Human Rights. Thanks so much.
Thanks. Rona, do you want to start?
Yes, thank you very much, Julieta, and thank you very much, Stephanie, for your question. So, yes, in relation to stakeholders, yes, I have done some work with stakeholders. So, I've had good contact with Women's Aid, which is probably the largest NGO in my own country that seeks to assist victims and survivors of domestic abuse, and I've also done a little bit of work with the police and with judges here in Northern Ireland, and also with the Executive Office, which is one of our government agencies here in Northern Ireland, which has recently produced a strategy on violence against women. In terms of how NGOs sort of approach developments in the European Court of Human Rights, one thing that I do believe is that I think sometimes developments at sort of the Council of Europe level, or indeed the UN level, are frequently not, there frequently isn't enough awareness of them. I think at the grassroots level, whether that be amongst the public as a whole. And I think sometimes there is maybe a disconnect between, what happens at activists at the grassroots level and what's happening at something like the European Court of Human Rights. So I think maybe that is something that could be developed further, because I think there are all of these criticisms about human rights law, about whether or not, the extent to which it is actually effective in changing practical situations. And one thing that I think could help would be for activists at the ground level to kind of perhaps use the judgments of something like the European Court of Human Rights more to place additional pressure on the government to take more steps to provide an effective response to victims of domestic abuse. So it's certainly an interesting question. I think there is certainly some sort of a disjuncture between what is happening at something like the European Court and what happens at the grassroots level. And I think perhaps more of a connection could be made there. So I hope that goes some way to answering your question, Stephanie. I'll hand over to Julieta then.
Thanks so much, Ronagh. Yes, please, Julieta.
Thanks. So for victims of domestic violence, I did a research stay at the Public Prosecutor Office in the city of Buenos Aires. That it's a place where it's kind of like the entrance door for many of these domestic violence complaints. And by the time that I was doing the research, it was an office that was very innovative because they had multidisciplinary support for victims. So as soon as there was this complaint, you had a group of psychologists assisting the victims and also the prosecutor. So there, what I did is I went to the Public Prosecutor Office for 6 weeks and interviewed all those victims who accessed and accepted to be interviewed. And then I contacted these victims again after 6 months, and because I wanted to understand this legal empowerment, so how they gain empowerment as they were going through the justice. So after 6 months, I contacted them again over the phone to ask them how they were doing and to understand that relation. And yes, I also interviewed all the group of psychologists that were working with victims, prosecutors, judges, the director of this office. So for that, I have quite a comprehensive sample of all those actors who were involved within the Public Prosecutor Office and the victims. And there I got a sample of 58 victims and 32 or 30, I cannot recall, I think 32 I managed to interview twice. The rest I couldn't connect again. And for adolescents, and there I used in-depth interviews and observations and questionnaires to get sociodemographic information. For adolescents, we developed a design where we also visited the care homes. We visited 3 care homes and we worked with a specific group of female adolescents. These care homes were mostly with female adolescents. And then we used participatory methods. So there we did art. So we asked them to draw or to express themselves the way they wanted to show or to say how they felt about what they wanted to express since they came to the care home, to see how justice played a role there. And then we did an in-depth interview to understand their art expression and ask them some questions. And then we asked them to perform a play. So we visited them 3 times. And then we asked them to perform a play, and we gave them the title of the play, and then we asked them to write a script and to perform. And the title of the play was Who Hears Me? And then it has 4 scenes, and they had to do that. And then as a validation element, we invited them to present with us in one conference. So some of the adolescents were with us presenting on how they experienced the methodology. So we didn't ask them to go through their experiences, not to re-victimize, but yes, to share with the public how they experienced the methodology that we used.
Wow, this was really interesting. Also, a very innovative approach. Great.
Yeah, it's nice to work with people. Then you really kind of like get to understand them better.
Yeah. Oh, great. Even a play. Wonderful. So I'm afraid we have reached the end of our webinar today. I would like to thank in particular our two speakers for amazing presentations. Thanks so much for accepting our invitations, and also the audience for all your questions and comments. And we hope to see you the next time again when EnRoL is on. Thanks so much, and wishing you a good afternoon. And to Lucia, if she's still around, I wish you a good morning to Brazil. Bye-bye.
See you
Thank you very
next
much.
time. Bye-bye.
Bye.
Pleasure to be with you.
Thank you.
Thanks.
Thank you.
Bye. Bye.